Hi, everybody. Good morning, and welcome to class number 7 of our 2026 virtual HOA and Condo Academy. Today is Tuesday, July 21st, and we have our class today, and we're going to be talking about the 2026 Arizona Legislative Update and case law pertaining to associations. That is relatively new case law that is impactful and is going to affect your associations. I'm going to give a few seconds for people to join us today and get settled. But first, I'd just like to welcome you to class number 7 of our 2026 virtual HOA Condo Academy. We partner with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe to teach these classes, and we're very appreciative of that partnership. And we've been doing this now for many years, over 6 years. Our firm currently represents, Mulcahy Law Firm is our firm, and we currently represent over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Today's focus is going to be twofold. We're going to be talking about the latest Arizona legislation, which affects HOAs and condominium associations first. And then we're going to spend just a little bit of time also talking about a new Arizona Court of Appeals case that immediately changes how boards must conduct regular and executive or closed board meetings. Our goals for today are pretty straightforward. We're going to simplify the new laws, make them really easy to understand, so you don't have a lot of questions after today. And we're going to highlight the emerging legal trends in Arizona community association law, because a lot of the new statutes are kind of trends that we're starting to see. And then we're going to give you some practical steps that your board can take to comply with these new laws and the new case law, especially with regard to executive sessions. So we're going to have questions at the end, like we always do. I'm going to conclude the main presentation probably a little bit earlier today because we have a little less content, and then we're going to save the balance of the time for your questions. Due to the large volume of attendees today, please note that there's one question per attendee. And if you're joining us on Zoom, please submit your question in the Q&A box, and we'll be sure to add it to our question list. If you're joining us on Facebook Live, please type your question in the comments section. Okay, so as some of you may see on your screen, if you're joining us on Zoom, we have a poll. So the first question is, which city do you reside in? And then the second question is, what is your current role with the association? So it looks like we have a really great turnout here today. I'm really happy to see, looks like over 190 people here today on Zoom and Facebook Live. So amazing turnout. And it looks like we're just computing some of those results. So I'm going to wait here a second. Let's see, I think we're in. So today we have a great turnout. We have 13% here from Chandler, 5% from Glendale, 4% from Goodyear, 33% from Mesa, 5% from Peoria, 10% from Phoenix, 18% from Scottsdale, 7% from Surprise, and 4% from Tempe. So really great turnout today from many of the different cities that we are partnering with. Secondary, we have the different attendees that are here today. So we have 69% of you are board members, 10% are community managers, and 21% are interested homeowners, with 1% being the other in attendance today. And so great results here today. Thank you so much for being here. And let's get started right away with our presentation. Before we start, I wanted to just talk a little bit about grants and rebates. Many cities, towns, and municipalities are just resetting their fiscal year. And this is a great time for associations to start thinking about whether your association may qualify for a rebate or some grants from the city, town, or municipality that you currently your association is located in. And so I want to take just a few minutes to talk about that. So as you start thinking about your budget for the coming year, don't forget that many cities, towns, and municipalities, especially the ones that partner with our firm to teach this neighborhood services virtual HOA Academy, offer grants, rebates, and neighborhood programs that can help stretch your HOA and condo dollars. We've put together a summary of all the programs that we're aware of with regard to the cities, towns, and municipalities that partner with us for these classes. And the different programs are amazing, and it's like free money for your association. So you really should look into it as a board. It covers things, these grants and rebates cover things like HOA matching funds, neighborhood grants, and water conservation rebates for turf removal and irrigation upgrades. And, sometimes it's like 50-50, meaning like we've had associations that put in a new monument sign. And what will happen is, the city may pay for half, and then the association's, board using associations funds pays for the other half. We've also seen that with improved lighting for associations. So lots of opportunities with these grants. And right now is the time to act because the money is resetting as of July 1st. So we have a blog on our website on this great topic that kind of keeps you updated about what the different links are for the programs and how you can potentially have your association apply for them. And so we're going to be sharing that link with you now if we haven't already. And we also have this information on our website, and we did a blog on it recently. Okay, so let's talk a little bit about our main presentation for today. I want you to think about this as your operational update for your association. Basically, what has changed under the law with the 2026 Arizona legislative session? What does it mean for your association? How your board needs to pivot to start doing things differently in light of the new legislation, especially around meetings, open meetings and executive session meetings, disclosure statements that you're giving to buyers, and then enforcement of your association's documents. To make this easier, I'm going to give you a quick roadmap of where we're headed. So these are the laws and the cases, and the one case that we're going to talk through basically in this order. So we have, let's see here, 8 different areas that we're going to cover today. And the first one is going to be Senate Bill 1184. And this is going to expand the flags, the current flag law in Arizona. Then we're going to switch over to Senate Bill 1246, which brings the Condo Act and Planned Communities Act lien foreclosure thresholds so that they are, going to be the same. Last year, the Condo Act was amended, and this year now the Planned Communities Act was amended. Third, we're going to talk about Senate Bill 1290, along with a new case. And we're going to kind of delve into executive sessions and some important updates with regard to not being able to vote anymore during executive session. And then fourth, we're going to go to Senate Bill 1808, which protects the display of a specific allied country's flag, practically the Israeli flag, and those will allowed to be flown, regardless of what your documents may say. And then fifth, we're going to talk about shade structures and a new, law that impacts an owner's ability to have a shade structure on their property in a planned community. Six, we're going to talk about a major overhaul of the resale disclosure statement, which is given to buyers when they purchase a home or a condo in an association. Seventh, we're going to talk about kind of a nebulous law, frankly, talking about a duty for boards to act reasonably and on when they're making decisions and codify some fairness standards that the legislature feels that the board, needs to be really careful when they're making decisions and treating owners similarly. And finally, we're going to talk about Senate Bill 1473, which is a municipal level law, which is going to make it easier for assisted living homes to move into your HOA. So we'll talk briefly about that as well. A couple of things that we're going to, mention is that, these laws do not go into effect until September, and I think my team may need to put that exact date in there for me. But many of these laws do not go into effect until 90 days after the legislative session ends. And I don't have the exact date right in front of me, but I know my office is going to be real quick and get that for me. And so we have a little bit of time to get our arms around these laws and to, get comfortable with them before they were going to be going into effect in September. Let's talk a little bit about the first law that we're going to be discussing here today out of the 7 changes. And before we do that, I'm just going to mention that all these new laws go into effect on September 12th, except for the case law that we're going to talk about, which was effective back when the Court of Appeals decided it. Okay, so Senate Bill 1184 addresses uniform services flags. And this bill applies to both planned communities and to condominiums. And it's going to expand the existing protections for flags of the uniformed services of the United States by providing the division flags for Army, Navy, Marine Corps, Air Force, Space Force, or the Coast Guard are included in the category of flags that associations cannot prohibit. A division flag is defined as a flag officially authorized by one of those branches to represent a division level unit and bearing the unit's approved insignia, designation, or nickname for ceremonial, identification, or representational purposes. For condominiums, this particular bill also eliminates ARS 33-1261L, which currently provides that a condominium association forfeits its lien rights for 6 months if it violates ARS 33-1261C, which is the for sale, for rent, and for lease sign rules. What this means for boards is really pretty straightforward. Associations may not prohibit properly authorized division-level military flags. How often are we going to see this? I honestly do not think very often. Boards should review their flag policies, though, if you have them, or sign policies, and update them if needed to include these flags that are now protected under Arizona law. Condo boards should also understand that while sign rules still matter, violating that statute no longer automatically wipes out the lien rights for 6 months. And the practical takeaway here is pretty simple for associations, whether you're a condo board or a planned community board. Do not try to restrict any properly authorized division flags, and make sure that your policies reflect the new law. Now, if you have something in your CC&Rs that may conflict with this, when the next time you do a CC&R amendment, we will correct that as part of the amendment process. But regardless, this law is going to trump your CC&Rs, so you need to allow these uniform services division flags, even if your documents, your CC&Rs, don't allow it. Okay, let's switch gears now and talk a little bit about Senate Bill 1246. And this deals with expense liens and special assessments. Senate Bill 1246 applies to both planned communities and to condominiums. And basically what this bill did is it's aligning the Planned Communities Act now with the Condominium Act in terms of the common expense lien foreclosure thresholds. And basically this law was changed for condominiums last year. Now they're aligning with the Planned Communities Act with the Condominium Act. And what it says is that under this law, an association may foreclose its lien only if the owner has been delinquent for at least 18 months or owes $10,000 or more in unpaid assessments, whichever occurs first. This bill also provides that for any special assessment with an initial value of $10,000 or more, only the 18-month delinquency threshold applies. And for boards, I would say for planned communities, the key point is that HOAs and condominiums now share the same foreclosure thresholds. And if a special assessment starts at $10,000 or more, you cannot foreclose early simply because the dollar amount is high. So if you have a special assessment that is, $10,000 or more, you're going to have to wait 18 months before you can foreclose. Practical realities of this bill, after, living with it with condominiums for a year, it typically is going to delay the foreclosure process a little bit. And so most of our associations are, they're hitting the threshold of the 18 months before the $10,000 that's owed in regular assessments. And so it's just kind of pushing things back a little bit for associations to be able to foreclose. So I would say we have a nice little window here for the next 7 weeks. And if you have anybody that, you are thinking about foreclosing on in a planned community, now is the time to act. So definitely reach out to our firm, and we can help you get that filed before September 12th, which will be the effective date of this new law. Okay, the next bill we're going to talk about is Senate Bill 1290. And in conjunction with this bill, we're also going to talk about the new case that was decided by the Arizona Court of Appeals. Interestingly, the Court of Appeals case was decided before the governor signed this particular bill. So let's just talk a little bit about what this means for associations. This is talking about executive sessions. This bill, Senate Bill 1290, interestingly, only applies to planned communities. But the new case law applies to both planned communities and condos. So uniformly, this is now going to be procedures for planned communities and condominiums. And basically, let's talk a little bit about the Court of Appeals case first. The recent Arizona Court of Appeals case is called AZNH, Revocable Trust versus Sunland Springs Homeowners Association. This particular bill, which was decided by the court prior to the Senate Bill 1290, it clarifies that both HOA and condominium boards should not take action in executive or closed session meetings except as allowed by statute. Basically what that means is anytime that a board's going into executive session, you can discuss things as a board as long as you're discussing one of the approved executive session topics, but no more voting is going to be allowed in the executive session. So all of your voting is going to be taking place in the open session now, whether you're a planned community or a condominium. And it's been a little bit of an adjustment. We've been living this with this now for a couple of months. And honestly, I think it's different for our clients, but it's nothing that is so difficult that you can't comply with it. In fact, what we're finding is boards are having fewer executive sessions and just opting to discuss everything pretty much in the open session, unless, they're only going to executive session now, typically just to discuss like legal advice, or if there's pending litigation, or they're thinking about suing an owner or pending litigation. Those are going to be the main topics that they're discussing. But again, all voting needs to take place in the open meeting. And, with regard to things that maybe we used to be discussing in executive session, what's happened on this is that we're just discussing it now in the open session. So for example, delinquencies, violations, like maybe performance reviews, if you're having that. Sometimes those are areas of improvement. Those now may be discussed during the open session, and maybe you're using the lot number or the unit number as an identifier instead of the owner's name. So a couple things about this new law that I think are important and this case law that are important is the agenda has to have very specific detail. And so both the executive session and the open session need to have sufficient detail so that owners know what's going to be discussed. Also, we're recommending that boards have in the minutes or have an official policy, which we can help you put together, as to who makes the agenda for your community. Most boards, delegate that to the board president. If you have a management company, maybe they're working together to put the agenda together. But it's clear from this case that the court, they remanded the case back so that it could be determined whether or not the president actually had authority to make the agenda. So we're suggesting that you, as a board, have a policy in place and have that in the minutes so that it's clear who makes the agenda. And so really those are kind of the main points on this. It's an adjustment, but ultimately, I think it will make your meetings shorter, because you're not going to typically have a long executive session and then a long open session. Everything's being pushed right now into the open session, basically. And maybe you're saving a few topics, like an employee review might be, something that you're discussing, and maybe litigation. And, those are the advice from your attorney in executive session. It's shorter because you're not voting. And so most of our clients are adapting really well to it. And frankly, a couple people have told me that they really do prefer it. Um, and so I think we have, if you want to copy that case, you certainly can find it. And also, you're welcome to review the new chartered version of this law as well. Okay, let's switch gears and talk about Senate Bill 1808. This is kind of an unusual bill that we would see this bill this year. But this bill pertains to allied countries' flags. And Senate Bill 1808 applies to both planned communities and condominiums. It's kind of strange that we have two bills on flags this year because truly we hardly ever get questions from our clients regarding whether a flag is allowed to be flown or not. So it's kind of ironic that we have so many bills each year that deal with flags. But basically, what this bill says, and again, it applies to planned communities and condominiums, is no matter what your association's documents say, associations may not prohibit the display of a flag from a nation that is aligned with the United States as a major non-NATO ally. And that was established on May 14th, 1948. This definition corresponds with only to the national flag of Israel. So as a practical matter, associations cannot prohibit the national flag of Israel, even if the CC&Rs or rules would otherwise attempt to do so. And boards should, update just like we talked about with the military division flags, boards should update any flag display rules that you have to reflect this protection and avoid any enforcement that would conflict with the statute. Now, remember, if there's something in your CC&Rs that conflicts with this, just the next time that you amend your CC&Rs, make sure that you update this provision. And obviously, if don't enforce the CC&Rs if it conflicts with this provision. Okay, the next law we're going to talk about is House Bill 2342. This bill only applies to planned communities, and it talks about shade structures. And this bill provides that regardless of what your governing documents state, associations may not prohibit the backyard installation or use of a shade structure. And at the same time, associations may adopt reasonable rules regarding the size, placement, and or appearance of a shade structure if those rules do not prevent the installation, impair the functioning of the structure, restrict its use, unreasonably affect its costs, or exceed applicable municipal zoning ordinances regarding height and setback for single-family homes. So the statute also gives us some direction on what a definition of a shade structure is, and it's a commercially produced or professionally manufactured movable or permanent structure designed to protect an area from sunlight, including an umbrella, awning, shade sail, gazebo, pergola, or canopy. And for planned community boards, what does this mean for you? You cannot outright prohibit backyard shade structures anymore, but you can adopt reasonable rules. But again, those rules cannot effectively make the installation impossible, impair function, restrict use, unreasonably increase the cost, or be more restrictive than local zoning rules. Practical takeaway here for boards that are planned communities. Take a look at your architectural guidelines and take a look at your CC&R, see if there's anything in there that might conflict with this new law regarding shade structures. If you have something in your architectural guidelines, you may want to check to see if it needs to be updated or amended to, comply with this new law. If you have something in your CC&Rs that violates this, the next time you do a CC&R amendment, make sure that you update that section. In the meantime, follow this new, bill that it has now in effect. So House Bill 2342. Okay, let's talk about House Bill 2397. This deals with resale disclosure statements, and this applies to both planned communities and to condominiums. This is probably one of the biggest operational changes from the 2026 legislative session because it does kind of significantly expand and revise the resale disclosure requirements. And many of you that have a management company, your management company is just going to be seamlessly taking care of this for you starting September 12th. The form will be updated and just the new information should be provided. It gets trickier for self-managed associations because you may not be aware of, these changes and you're going to need to update your form. If you need any help doing that, you may just want to create a form that is, that you can be used you can use for any resale disclosures after September 12th, and our firm would be happy to help you with that. Okay, the first change on this new law is that the timing changes on it. So disclosure obligations by the association. So by disclosure, I mean like information about the association to a potential purchaser are now tied to the acceptance of the purchaser's offer instead of merely notice of a pending sale. And the law allows us to send by electronic transmission the required disclosure items to a purchaser, which makes things so much easier. It also provides that the disclosure statement may be sent to the purchaser's designated agent, such as like their realtor or their lawyer, whoever they decide to be their agent. And for an association that has 50 or more units, the seller must provide written notice to the association that includes the purchaser's email address in addition to the purchaser's name and the mailing address. Kind of the second part of this new disclosure law or changes to the disclosure law is that what's the content of what is disclosed to a buyer also is expanded and changing. So the law is adding a request or a requirement that we provide the final plat for the association, board-approved minutes from the previous 3 open board meetings, certain condominium insurance certificates, declarant control information, like whether you're under declarant control or not, investor concentration information for condos, if you have it, and a statement about the purchaser's right to review the full reports that were summarized, and a statement addressing multiple association properties and related resale disclosure fees. Third, the dated disclosure statement also expands. So it now includes payment schedules for annual assessments and any approved and assessed special assessments, recently approved or recently proposed special assessments. So that's a big change. Previously, unless it was, due, we were not typically going to be disclosing that. Let's see, certain condo deficiency disclosures, probably in light of the Surfside towers that collapsed in Florida, current unpaid assessments that are owed by that particular lot or unit owner that's selling, any liens or list pendants on the property. List pendants is going to be tied to a foreclosure on the property. Transfer fee information, the association's most recent income and expense financial statements for operating and reserve accounts, and any outstanding unresolved violation on the property. So if there's any violations on the property, we're going to be disclosing it to the buyer. This bill is also going to change existing disclosure requirements by requiring current bylaws, current rules, and the current recorded declaration to be included in the resale disclosure statement to the buyer. If the most recent reserve study is more than 10 pages, we can do a summary instead of a full report. But remember, I said a few minutes ago that if they want the full report, they can ask for it, and we have to provide that to them. And the purchaser must now sign the required contractual acknowledgement. So there's a statement that the purchaser has to agree to at the close of escrow rather than within 14 calendar days. So hopefully that will get the purchasers to sign that statement saying that they understand that they're, purchasing a lot in an association or a unit in an association, that they're contractually bound by the terms of the documents, etc. And we had problems in the past where owners were just refusing to sign that. But if it's part of the close of escrow, that's just going to be one more form that they're required to sign. So hopefully that will be a good thing. The law further removes the lien extinguishment language from the resale disclosure statutes for an association's failure to timely provide required disclosure information, but it does not eliminate the separate lien extinguishment consequences that remain in the lien statutes for condominiums and planned communities. So it was like a double, and they took that out. So it still exists in the lien statutes that this can be done. It primarily removes redundant wording in the resale disclosure sections as well. The law also adds a good faith reliance provision, stating that disclosures may be based on good faith reliance on association records or information without the need for independent investigation or validation. So, the buyers are relying on the information that we're providing to, that the association is providing to them. It also changes the liability standard from mere failure to disclose to knowingly or recklessly failing to disclose. or knowingly or recklessly providing material that is false or misleading statements regarding the association. Finally, it's going to allow an owner to request an updated disclosure report if 30 or more days has passed since the original report was provided to them, and the association can charge a fee of up to $50 for that particular update. For boards and managers, the practical message is that the resale disclosure procedures and checklists do need to be updated based upon this new law by September 12th, 2026. Whether it's if you have a management company, the team that handles the disclosures, or whether it's a board that's self-managed, you really do need to be trained on the changes to this new law because this is pretty extensive, because there's a new timing trigger in terms of when we have to provide it. There's expanded content that we have to provide. And the information has to be correct. And the importance of documenting good faith reliance. We have to have the documentation that we've complied with this and it's correct. And so this is really a major operational change for associations. Once you get the form set up, though, it should be a relatively easy transition because you just follow the form. So if anybody needs help with that, if you're a management company or if you're a board, please know that we are here for you to help you update your forms to make sure that you're in full compliance with this new law by September 12th. Okay, the next bill we're going to talk about is House Bill 4011. And this is kind of a nebulous bill. It's very interesting that this was passed this year. It talks about a duty of a board to act reasonably. Now, I kind of feel like this bill, a similar provision is already in the Nonprofit Corporation Act for associations, and that's our fiduciary duties to act in the best interest of the association in good faith, as a reasonably prudent person would. It just adds another layer for boards to act reasonably when they're making their decisions. And this bill applies to both planned communities and to condos, and it imposes on an association a duty to act reasonably in the exercise of their discretionary powers, and describes that a duty as exercising discretionary powers, you have to do it neutrally, fairly, without favoritism, and in a non-arbitrary fashion. So something to think about as you're making your decisions. And this is very similar to the duty of care that's in the Nonprofit Corporation Act. It's basically just codifying what we've seen in a number of cases in Arizona that pertain to HOAs and condominiums and planned communities, what's in the Nonprofit Corporation Act about fiduciary responsibilities. As you're making decisions as a board, treat people fairly. You cannot selectively enforce violations against, one owner and not against another owner. So really be thinking uniform, fair, neutral, without favoritism when you're making all these decisions that pertain to, violations, delinquencies, and really rely on your legal counsel to help you if you're struggling with, hey, are we treating this owner differently than we may be treating another owner type of thing. Reach out to our firm. We're happy to help you if you're struggling with that or you're worrying, that you might be treating somebody differently, and is it distinguishable, and, are we potentially violating this duty to act reasonably? Okay, the last bill that we're going to talk about is Senate Bill 1473. This is kind of just an add-on that we put in here. This was actually one of the first bills that was passed this year by the Arizona legislature, and I thought it was interesting because it's going to make it easier for owners that want to convert their homes into assisted living facilities. It's going to make it easier for them to do that. And this is House Bill 4011. This applies to planned communities and to condominiums. And, I'm sorry, I was reading the wrong one. This is Senate Bill 1473. And it indirectly applies to HOAs and condominiums, okay? But it's not part of the Condominium Act or the Planned Communities Act. And basically, it's going to remove some restrictions that the government has placed and some barriers that to small assisted living facilities to becoming licensed and operational in communities. But it's not specifically like an HOA or a condo bill, but it's a bill that is going to allow people that want to convert or that want to build or want to change the use of their home into a small assisted living home. It's going to make it easier for them to do that. So Just some things to remember, the Fair Housing Act, there is an exception for um, assisted living homes to operate in an association, even though it is a business. And, so this bill potentially could allow to have more of them move into your association, because previously there were some barriers imposed by, the local government, saying that you can only have so many in a certain, geographic area or certain square mileage. And some of those restrictions have been lifted. So it's possible that you may see more of these in the coming years because of the changes due to Senate Bill 1473. Okay, so we have covered all of the new legislation for 2026. We have a great cheat sheet that we have kind of put together for all of you with the summary of all of these different bills. I know that we have a really great turnout here today. But some of your other board members may not be here, or maybe your management company isn't here today. So we would really encourage you to share our summary. And it's either going to be shared with you here on our Zoom meeting or Facebook Live. You can also find it on the homepage of our website at mulcahylawfirm.com, and it gives you a full summary of all of these legislative changes and also the new case law that pertains to no voting being allowed during executive sessions. So we hope that, these bills here today have been easy for you to understand, and I'm going to stay on here and answer all the questions that any of you may have pertaining to these new bills. So we're going to get right into that right now. Our first question is, the board held a special session last week to discuss whether it may legally share homeowners' personal information, such as addresses, emails, unlisted phone numbers, etc., with the community without each owner's written consent. The officers voted not to release this data. Under the new open meeting legislation, excuse me, does a special meeting qualify as an open meeting? And can the board lawfully make decisions by vote in a special meeting, or must those decisions be made in an open meeting? Excuse me, so there's a lot of questions here. Okay, so the first part of the question talks about, can the board legally share personal information about an owner? So let's talk about that quick. So homeowner's address, property address, and the owner of the property is already public record. So you can find that on the assessor's website, on the Maricopa County Recorder's Office, or any other county that may, the property may be located in Arizona. So sharing the name of the owner and the address of the property is already public record. So I don't really have any issues with you sharing that. Now, emails and phone numbers, whether they're listed or unlisted, those really are personal information, in my opinion. And unless the owner authorizes the board to share that with a third party, I would not, as a board, I would not advise a board to do that. So if an owner authorizes to include that in an owner directory, or when they give that to you voluntarily, there's a little statement saying, hey, this can be shared and disclosed to other owners, that then you can share it. But otherwise, I would advise against sharing that. Okay, the question, so it sounds like your officers voted not to release that information. Certainly that's your right. You're asking under the new open meeting legislation. So I'm guessing that you were thinking about the new case law regarding executive sessions, not being able to vote in executive sessions. And so you're wondering if a special meeting will qualify as an open meeting. So, yes, any special meeting of the membership where you're talking about non-executive session topics, that's going to be considered an open meeting. Can the board make decisions by vote in a special meeting, or must those be made in an open meeting? Okay, so a special meeting of a special meeting of the board is just like an open meeting. Okay, if you're not talking about executive session topics, it's going to be, even though it's a special meeting, maybe outside of when you normally have your regular board meeting. So yes, you can make decisions in a special open board meeting, but you cannot make decisions in a special executive session meeting. Okay, so that would be the distinction. Okay, the next question. Does Arizona law prohibit a resident to post a sign that reads the following? Watch for motorcycles. We have no sign restrictions in our CC&Rs. So if you don't have sign restrictions in your CC&Rs and no rules pertaining to this, I really don't see any issue with an owner posting that sign on their property. Okay, next question, number 3. Our association is under developer control. Does this new case law apply to our association? Ideally, the developers should be having board meetings while it's under developer control. Um, my experience, though, typically is that typically they're not having regular board meetings while under declarant control. And so if they are having board meetings, then I would, argue that they should be following, the new law and the new case law on this, and no decisions during executive session. But my experience is that most developers, when under declarant control, are not even having regular board meetings. Okay, question number 4. I would like to speak to a board member face to face without the management company. What is the protocol? Well, first, there's no legal requirement that they have to meet with you individually without the management company being present. A good way to handle it would be just to find out who the board president is and ask if you could just have a few minutes to talk with that person. Remember, the president is a volunteer. All board members are volunteers. And, there's a reluctance, I would say, to meet individually with anybody because we don't want to get into a he said, she said thing. But, I'm guessing because you don't want the management company there that you're unhappy maybe with how the management company is performing, and you want to talk with the board president about this individually. What you might want to do is just say, hey, I have some concerns on something. I would like to just talk with the board and see if maybe the board will allow you to, be at the tail end of a meeting and they let the manager go a little bit early that day and it's just you and the board talking. That would probably be a good way to handle it. Or you could reach out individually to the board president and see if that person might be willing to meet with you and another board member and the president. I think that's probably the best way to handle it. Okay, question number 5. Oh, and one more thing on question number 4. If they refuse, there's really not too much you can do about it. Just come to the board meeting and, state whatever your concerns are during the homeowner forum at the, during the board meeting, the open board meeting. Okay, question number 5. Can new business be added after a printed agenda? This is a tough one. I mean, under the new case that was decided recently, the importance of having a detailed agenda is really, brought to our attention by the court. So in a perfect world, you really shouldn't be adding new business after a printed agenda is sent out to the homeowners 48 hours in advance of the meeting. But emergencies come up and different things come up. So, from time to time, there will be things that need to be added within that 48-hour window before the meeting, after the agenda is sent to the owners, but before the meeting actually occurs. So I would say, do your best to try to avoid that. But if it's an emergency and you need to do it, just state, hey, this is an emergency, and try to give them as much notice as possible. If it changes, if 24 hours in advance that you're adding something, shoot it out to the entire membership that, hey, this came up and we're adding this to our agenda. And this is an emergency issue that needs to be, discussed. Okay, let's see. The next question is, what option does one have when the board ignores the new open meeting law and continues to discuss and vote in executive session? Who or how do we report a board's violation of the new case law to? Okay, here's what I would say. Remember, board members are volunteers, and this new case was just decided very recently. And we're still getting the word out to, the 10,000 associations in Arizona about this new case law. And remember that the new statute doesn't go into effect until September 12th. But the case law, in my opinion, applies to planned communities and condominiums effective immediately as the date that it was decided by the court. So what's a good way to handle it? You may want to send them a copy of the case, or you may want to send them a clip of this recording where we talked about it. And just do it in a nice way. Just let them know, hey, you may not know this, but there was a case that was decided, and now we need to have all executive session, topics are voted on during the open board meeting. If they continue to violate it, then a couple different options that you have. You can send them a letter in writing or an email documenting your concerns. You can go to the ADRE, the Arizona Department of Real Estate, and file a complaint against the association. You have to pay a $500 filing fee to do that, and then you'll have a hearing in front of an administrative law judge to hear the case on this issue. You can, file a lawsuit, although this seems it's kind of a small thing to be filing a lawsuit on. But it's an option, a legal option that you have. So hire a lawyer, ADRE, file a lawsuit, friendly reminder first. These are all tips on how you can get your board to comply with this. Okay, next question, number 7. Our CC&Rs limits the number of dogs or cats to 2. Is this still enforceable? So generally speaking, yes. If your CC&Rs are a contract and, generally speaking, this is enforceable. There might be an issue if somebody wants to have more under the Fair Housing Act. They need it as like a service animal or emotional support pets. You may have to, allow that. But for the most part, the CC&Rs are a contract. And if that's what the contract says, the association can enforce it. Okay, next question. Number 8. Who has responsibility for auditing the expenditures, the management company or the board? So, and under both the Planned Communities Act and the Condominium Act, associations have to conduct an audit review or compilation every year. Now, who conducts that audit review or compilation really is dependent on what your bylaws say. If your bylaws require you to use a CPA to do it, then you have to have a CPA handle the audit of the association's books and records. If your bylaws are silent on, having an audit done by a CPA and how often, then really it's up to the board to decide how that audit review or compilation is handled. I would advise against the management company doing it because we're really auditing the association books, which they have financial control over, right? So we want to have an independent party doing the audit review or compilation. So maybe a committee, a bookkeeper, a CPA, those are going to be good independent individuals that would be able to do the audit review or compilation. Okay, next question. Let's see. Is there an industry standard for HOA fidelity bond coverage in regards to annual assessments, operating budget, and a reserve fund? I think that's a really good question to pose to your insurance agent. How much is enough for our fidelity bond? And maybe you can show your financials to the insurance agent and be like, okay, here's what we have in our accounts. What do you recommend? In my experience representing associations for the past almost 30 years, I can tell you that fidelity bond coverage is usually pretty low if you just go with the standard. It's usually like 50 grand. And so, that would be something that I would strongly consider having that be a larger amount than the standard 50K. I know I've seen many associations go through like fraud and embezzlement over the years, by many, I mean, probably like 15 or 20. And that's a lot, that had either the management company stealing money or a board member stealing money. And when you go to look at the insurance to see if there's coverage for, the embezzlement or fraud or whatever, and there's a lot of money that's taken. I can think of one instance where it was over $500,000 and, to only have a $50,000 fidelity bond, it's not enough. So pose that question to your insurance agent and, really think about it doesn't cost that much more to increase it. So it's a very good question. Okay, next question is number 10. Would you consider a vendor invoice as basic records that must be available and maintained? So yes, that is something that can be, requested by an owner. Now, mind you, the association could redact out how much was paid, under the law, but they still have to provide the invoice. However, I really recommend associations not to do that. So can homeowner request that those be produced per Arizona statute? Yes, but again, the board may have they may redact how much is being paid to the vendor, although I really advise my clients not to do that because there's so many other places that the owner can find it on the year-to-date budget, etc. Okay. Question number 11. Is there a standard expenditure dollar amount that a condo president, vice president, or treasurer can approve without full board approval? This is making the assumption that the expense item was not included in the year's budget. I think your board just has to decide that. I know I'm on my board. I've been on my board for many years, and I think our maximum expense that the president can spend is $5,000. That's not budgeted, and usually it's regarding like an emergency type situation, where the pool pump needs to be fixed quickly, and they authorize to have the pool company come out and fix it. But it's specific to your association, so you have to talk about it, and you have to come up with a number and then have that vote and put it in the minutes. Okay, next question. Let's see, is number 12. We are currently experiencing board infighting, and it's costing our association a lot of money in legal fees. We want to clear the air and see if we can figure out what's behind the issues and if we can resolve and come back together as a board. There's some dispute as to if this should be done in executive session or open session. I have a really good idea for you. So we have seen a lot of associations that have, a high level of dysfunction, and they can't get things done because they're fighting about so many different things. And, having a boot camp with our firm or with another law firm that may represent your association and air the grievances. This can be done in executive session because you're going to have legal counsel present there or giving advice. Anytime that I have gone into a boot camp with a board to discuss how can we move forward as a board, how can we eliminate the dysfunction, how can we get things done, how can we set aside our differences, I 100% can tell you that the issues have been quickly resolved. It takes about an hour and a half. We air grievances. We talk about a path forward. We talk about different personality types and how that may, impact, how the board operates and how the board makes decisions. And it's what I would say a very productive and positive experience to work through the issues and move out of the dysfunction. So I would really highly recommend that you do that. You can do it in an executive session. There is a cost to do it, but the cost is going to be well worth it because you're going to actually be able to get things done now going forward. Okay, question number 13. Can we still have written unanimous consents for board approval on different items? And so I do not recommend that associations use actions by written consent to make decisions for your community. Really, the only time that I would say that would be okay is if there's an emergency and you cannot wait 48 hours to make a decision. Otherwise, all decisions of the board need to be discussed during the open board meeting that's properly noticed 48 hours in advance with a detailed agenda. Okay, question 14. Are you saying that you can talk about delinquent accounts by unit number in an open session? So short answer on that is yes. I really don't know any other way to do it based upon the new case law. So, the legislature and the new Court of Appeals case, we can't have it both ways, right? We can't, they're telling us that, okay, these decisions need to be made by the board in the open session. So we can discuss the delinquencies and the violations in executive session, but we have to make the decision in the open session. And so we don't really want to use the names of these people. So we're going to use lot or unit numbers as the identifier for the minutes so that there's a paper trail of what was decided by the board on this. Okay, next question. Question number 15. How do we go about trying to update our CC&Rs without spending a lot of money? We previously had a failed amendment process and we spent a lot of money. Okay, I have a great tip for you. So our firm offers a free 15-minute CC&R amendment review. And so send us your CC&Rs. We will take a look at it. We'll tell you what it takes to amend your CC&Rs. We'll give you our suggestions for amending CC&Rs from your particular set of CC&Rs. We spend 15 minutes on it. We don't charge you. That's a good starting point. After you receive that, you want to look at our cheat sheet called Amending CC&Rs, a 5-step plan. Now, this is kind of like a secret recipe on how your association can be effective in amending your CC&Rs. So if you're going to spend the money to create amendments to your CC&Rs, and you're going to put all the time in to create the amendments and talk about it at a board meeting, and then you're going to send it to your owners to get it approved, and then you have to record it. You're going to be spending a lot of money along the way, and to have it fail in step 4 when we're sending it to the homeowners for a vote, that shouldn't be happening. Okay. So we have this 5-step plan where we, identify what the amendment procedure is, and then we come up with the amendments together with the board and legal counsel. And then the third step is we go to the homeowners and say, well, what do you think? Before they're voting on it, we ask for their feedback. And then we take their feedback, and in step 4, we make the amendments. We change the amendments if they need to be changed based on the feedback, so that it's palatable for people to vote yes on them. And then the final step is to record the amendment, after we get the requisite votes. So take a look at our cheat sheet. I think there's some really good suggestions for you on how to do that, and in a cost-efficient way. Okay, we're down to our last 3 questions. According to Bill 1473, are you saying that an HOA 55 and over community could be required to have a resident use their home as an assisted living home? Please clarify, as if yes, this would be very concerning to our residents. Okay, take a look at our cheat sheet on federal laws. I'm not saying that this applies just to 55 and over communities. I'm saying this applies to, this law is it's a law that applies to municipalities. It's not specifically in the Condo Act or the Planned Communities Act, but it says that it's easier for municipalities, cities, towns to approve assisted living homes, small assisted living homes, in the, areas that the municipalities, have jurisdiction over. And so, yes, there can be, under federal law, the Fair Housing Act, there is a specific carve-out exemption for assisted living facilities. So that has always been the law. So take a look at our cheat sheet on federal laws. That's going to have some good information for you on that. And why, even though it is, operating a business out of a home, how that, is allowable under federal law. And it's an exemption under the Fair Housing Act, and associations cannot prohibit them. Now, that being said, in the past, before this law, it was, could only be a certain number of assisted living areas, depending on what the municipality's ordinances or regulations were within a certain geographic area. Now, some of that has been lifted now. So we anticipate that there will be more requests to the cities, towns, and municipalities for assisted living facilities. And, it has to specifically qualify under the Fair Housing Act. Like, it's going to have to be for persons with disabilities as defined under the Fair Housing Act, or, there's a number of different other categories. So, yes, take a look at our cheat sheet on federal laws. I think that will be really helpful to you. Okay, last 2 questions. As board members or volunteers, is there a need to have liability insurance? So yes, absolutely. Your board should have directors and officers insurance, or E&O, errors and omissions insurance, for your board members. And depending on the size of your association, it should be somewhere in the $1 to $5 million range. And you don't have to have any individual separate insurance. Some board members, like very rarely, like 0.0005%, some get like an extra liability umbrella on their personal home because they serve on the board, but it's not necessary. Well, you should get, for your association pays for it and it covers all of your board members, is directors and officers insurance, or E&O insurance, errors and omissions insurance. Okay, last question for today. Can a board approve an architectural request by an email with unanimous approval without notifying the homeowners with prior notice? Okay, this is kind of a loaded question. So, I don't like approving anything as a board outside of a board meeting, an open board meeting, based upon the new case law and based upon the open meeting law. Remember that the open meeting law says that anytime a quorum of the board is present discussing association business, it needs to be an open meeting, right? And there are certain exceptions under the executive session laws, but there's really only 5 categories that falls under. So it sounds like your board approves or disapproves architectural requests. It's a risk if you're doing it by, unanimous written consent outside of a board meeting. Somebody could challenge it. So you just need to know that. It would be best to do it in conjunction with your open board meetings going forward. Okay, wow, we had a great class today. We're right on time. It's 59 minutes in, so we had a wonderful turnout today. We had 233 viewers today at peak, which is amazing. This is a new record for 2026, so we know there's a really high level of interest on these new statutes in Arizona and the new case law, and really we have like 7 more weeks to get our arms around it before the September 12th effective date, 2026, of all these new bills. If you found this presentation helpful today, I'm going to ask you a favor, please. I would truly appreciate it if you take a moment to leave us a positive review on Google, Yelp, or Facebook. Your feedback means a great deal to us, and then we can provide that feedback to the different cities that we teach these classes for so that they will continue to sponsor our firm teaching the Neighborhood Services Virtual HOA Academy every month. So that feedback is really important. So I would appreciate it if you wouldn't mind giving us a Google, Yelp, or Facebook review so that then we can share it with the different cities. These classes take a great deal of time and effort to prepare, as I'm sure you can imagine, but we really care deeply about providing useful, practical education for board members, managers, and homeowners so that we can build great communities, HOAs, communities, and condo communities in Arizona. And your feedback that you're giving us by asking questions and giving us, reviews on different social media platforms like Google, Yelp, or Facebook helps us know that we're moving these classes in the right direction and providing useful information to you so that we can continue to help your associations evolve and change as there's new case law and new legislation each year. We really appreciate you caring about your communities and being here today. Thank you so much. Share it with your boards and share it with your manager, the information that you learned today so that we have everybody operating consistent with the new legislation by the effective date of September 12th. And we hope to see you at some of our future classes. And one of the most next class that we're going to be teaching is our First Friday class. And that's where we hop on Facebook and on Zoom and answer your questions live for an hour between 9 and 10 a.m. or until we answer every question. Sometimes it goes a little longer, and that's on Facebook and Zoom. Also, we have our August live virtual HOA and Condo Academy in partnership with the different neighborhood services departments on Tuesday, August 18th from 11 to 12 on Zoom and Facebook Live. And we're going to be talking about effectively managing enforcement and violations in an HOA and a condominium. So that's going to be a great class. We're going to be talking about all sorts of different things, whether it's how to handle violations, how to handle delinquencies, owners that aren't paying their dues, etc. So we hope that you will consider joining us for that particular class. So thanks again for being here today. We hope you have a great rest of the month, and we look forward to seeing you at our First Fridays coming up the first Friday in August. Take care, everybody, and have a great rest of the month.